Good morning. I'm Mark Kimball, Chair of the Citizens Clean Elections Commission. It's 10 a.m. on Thursday, December 11th, 2025. I call this meeting of the Citizens Clean Elections Commission to order. With that, we'll take attendance. Commissioners, please identify yourselves for the record.
Christina Werther.
Galen Payton.
Sam Crum.
And I'm Mark Kimball. We have a quorum. 4 of the 5 of us are here. Item 2, discussion possible action on meeting minutes for 2 meetings. I'm sorry, I see Commissioner Titla is now here with us. Commissioner Titla, are you here?
Yes, sir. Good morning, Chairman. Good morning to everybody.
Good morning, Commissioner Titla. All 5 of us are here. Thank you. Item 2, discussion possible action on meeting minutes for 2 meetings, November 20th, 2025 and November 28th, 2025. Do any commissioners have comments or questions on the minutes before we move to a motion? Hearing none, is there a motion to approve the minutes for the 2 meetings on November 20th and November 28th?
Mr. Chairman, I move to approve the minutes for November 20th and November 28th of 2025.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded that we approve the minutes for November 20th and November 28th, 2025. I'll call the roll. Commissioner Werther,
Aye.
Commissioner
Aye.
Commissioner Titla,
Aye.
Chair votes aye. The minutes are approved 5-0. Item 3, Executive Director's Report. Tom?
Yes, Mr. Chairman, thank you. Thank you, commissioners, for all being here. A couple of highlights. First, I wanted to congratulate Commissioner Werther on being elected president of the Arizona City Attorneys Association. So I thought that was a cool thing. And that's all the city attorneys for all of Arizona's 91 cities and towns. 92. There's a new one. Oh, that's right. 92. It's Queen Creek. Santan. It's near Queen Creek, right? Sorry. Anyways, I thought that was super cool. So we also did this town hall panel discussion on healthcare with Telemundo on December 1st, and then it aired on the 4th and the 5th. You can see some of the panelists we had. We thought this was a great opportunity. This is the second issue town hall type forum that we did. I've done this calendar year, and I think I also say that everybody on our staff, Gina and then everybody working at Reister, and Telemundo moved very quickly to put this together on an expedited basis, and because we wanted to get this done timely during the open enrollment season. And so so this was really, I think this was really an important thing. And we'll have more of that as we get into next year. As you can see, everybody's sort of out. We don't have a lot of outreach activities going on. And we are working on the 2026 voter education plans. We've had 9 workshops so far, and we'll have the 2026 workshops coming up in January. On the cases, the only thing I wanted to update you is that we have a response due tomorrow in a motion preliminary injunction in Montenegro v. Fontes. So where that case is now, this is the case that challenges Prop 211 on the basis of separation of powers delegation principles. So essentially the legislative leaders saying that the delegates too much authority to the commission to administrate the Voters' Right to Know Act. So there's a motion for judgment on the pleadings that has been filed by the leaders that we responded to on Monday. Then they filed a motion for preliminary injunction. So we'll have hearings coming up at the beginning of the year on those. I think that the case that came out of the Supreme Court had to do with their standing, that is to say, whether or not they had an injury. This has to do with whether or not, in fact, there's a violation. And on the preliminary injunction, part of the question is whether or not they're harmed, irreparably harmed, which is not the same as just whether or not they have injury sufficient to be in court. So, those are still ongoing. We do have a discovery issue there too that we're working through with the leadership. I did want to mention two other things real quick. There was this argument on the 9th in this National Republican Senatorial Committee versus Federal Election Commission case that was, covered pretty extensively by all, in the news. That has to do with whether or not it's constitutional to restrict party coordinated expenditures with candidates. In Arizona, I don't know that a decision on this on a First Amendment basis will affect Arizona very much, because in 2016 we passed a law that said that party coordinated expenditures are not contributions to candidates, and they are not subject to the independent expenditure limitations that exist. So the more interesting question, probably when this case, a decision gets issued sometime before the end of June, sort of how deeply into the campaign finance limits law the majority of the Supreme Court cuts. Most states and the federal government have some form of campaign finance limits, that how much you can take and from whom you can take, and the money. So that's probably the most interesting thing there. This was, not to get super technical, but this was on cert. It wasn't a direct appeal, which you can have in some of these campaign finance cases. So they didn't have to take the case. So the fact they took the case, tells you a lot about where this is going. I also want to mention these two bills. Mike, as you know, for Mr. Crump, you don't know, but Mike puts out a legislative report starting with the session that'll be part of this executive director's report then. But we had two bills we wanted to highlight. One, Senator, I think pretty much every year, to change the threshold at which donors' identity would be reported. I was in Atlanta for this conference of government ethics lawyers, and there was a lot of discussion around, how this issue will play out in legislatures that are controlled by both parties, because of the concerns around just general how much information is out there about people and what can it be used for. So I think that, we'll be sensitive to that, obviously under the Voter Right to Know Act. In addition to those legal parameters that exist, the commission has the authority to, if we ever got an application, we haven't ever, to exercise its, authority and to address, safety issues if they were to arise, those kind of things. So, that's a timely thing. And I think if there was a year that this kind of bill would get, some momentum, it might be this year. And then the primary date, in, what was it, 2024? In 2024, for 2024, that they moved the state primary date. This was to account for the lower recount threshold that the legislature passed. It's very likely there'll be a bill that will, and this may be it, that will make that permanent. So instead of the first Tuesday in August, our primary would be the last Tuesday in July going forward if that passed. So those were, I just think there's so there's a number of things going on in the world that will have some relevancy to what we do. And I wanted to make sure that, as we go into next year, we sort of try to make you aware of those. So that's all. I think that's all I had.
Thank you, Tom. Are there any comments or questions from members of the commission? Hearing none, we'll move on to item 4, litigation matters, discussion and possible action. Item 4 concerns 3 matters. The first is the commission's suit against the Secretary of State. The second is a similar suit later filed by the Democratic Party. And finally, we have this notice of claim. As indicated in the agenda, the commission may consider authorizing a range of legal options and may vote to go into executive session for legal advice or to instruct our attorneys. Before we go any further, I'd like Tom to give us a brief summary of these matters, see if any commissioners have questions they would like to address in an open session. Tom?
Thank you, Mr. Chair. Commissioners, so, the commission voted to authorize the lawsuit, and we filed on December 2nd. It's a declaratory judgment action that, essentially seeks to a declaration that the Secretary of State, lacks the authority to, unilaterally change the name of a party and the in this manner. On later that week, the Arizona Democratic Party filed a lawsuit that, largely, I think reflects similar theory to ours. I think that's probably they filed it as a special action. So the major differences between a special action and our declaratory judgment action have to do, first, it's discretionary on the court whether or not they would take jurisdiction over this case in the first place. That's the most significant one. It's not necessarily clear that they get any more timely relief from that. And then we received this notice of claim. The notice of claim itself is it's been distributed by the attorneys who filed it to, I think, a lot of different reporters. So, the upshot there is that this really has more to do with the threshold number of signatures that independent candidates have to get than it has anything to do with the lawsuit that we have filed. There's a little conflation of those two things in some of the press coverage. And then there is some other aspects of that are a little idiosyncratic in the sense that if the threshold, so independents have to get roughly, well, in 2024, independents had to get for statewide office 42,000 signatures, while a Democratic Party candidate for statewide office had to get like 5,000. And the statutes basically say that an independent, and statute's been written this way, I think since I want to say the early 80s, maybe the mid 90s, but it says you take 3% of the eligible population of independent voters, I believe, is what they have to get. Something like that. So it's basically you end up with a much higher percentage of a much higher number. 42,000 though, quite candidly, I mean, it may not be that insurmountable. I mean, people say it's insurmountable. When you think about it, with equal and different things that you have now, it may not be. But anyways, that's the argument. It's essentially an argument that says that that's a violation of equal protection. So it really doesn't have a lot to do with what we're doing. There is some matters in there about objecting to whether or not we have a role here. So that's kind of where those things are. In the meantime, there is an aspect of this overall issue that involves the election procedures manual, and the elections procedures manual, the final election procedures manual. The deadline for that is the 31st. So before the beginning of the year. Not a lot of news to report, at least that I have, as far as where that is in the process. You will recall that one of the issues that the Motor Vehicle Division has raised and that the counties have raised is that the EPM itself says it identifies 5 parties. It doesn't identify a Arizona Independent Party. So if you're directing a set of county recorders to take an action, to the extent the secretary can even really do that, and that action is not one that is recognized in the EPM, that creates a real conundrum, right, for a county. You can't do both, literally, is what what their communications have said. So that's where we are. I think the thing that's and I think that I think that's really about all I have to just sort of summarize the sort of top news. So outside of that, I don't know. So I don't know if there are any questions about those factual issues, and I guess beyond that, I probably would, defer to Bill and to you all about what you want to do, and what when we want to go, when you would want to go into executive session.
Before that, are there any questions that commissioners have in open session?
Chairman,
Commissioner Titla.
yes, sir. Tom, regarding your statement, earlier you stated that this was discretionary. Were you referring to the commission's lawsuit or the Democratic lawsuit?
Mr. Chairman, Commissioner Titla, the what I was referring specifically to was the court's discretion to accept jurisdiction of the Democratic Party's special action. Just because, as you know, the special action rules just allow a court, unless you have a mandatory special action provision, to decline jurisdiction actions.
Yeah, thank you, because you said it was discretionary to this lawsuit, and there are a couple of lawsuits out there.
Right.
Commission's lawsuit and Democratic Party's lawsuit, so I didn't know which one you were referring to, but thank you for the clarification. Second, I have a question on, has the Secretary of State answered the pleadings that have been filed by the Commission and the Democratic Party?
Mr. Chairman, Commissioner Titla, no. Their answer, or whatever they will file the 24th of December. I think so. And I guess for the Democratic Party, I'm actually not sure. If their answer is due on the same schedule or if they get a different schedule for the special action. But we have been in communication with the Secretary of State's attorneys. But no, there is not yet been there won't be they don't have a responsive pleading due until the 24th.
Okay, if it's worth, is there a reply date for the Commission to that reply?
So, right, Mr. Chairman, Commissioner Titla. So, to that point, I think that one of the things that one of the things that I think is, sort of self-evidently in front of the commission as a plaintiff is, how to best execute getting relief in a manner that is timely. That's probably a better question for Bill and Samantha, but we have given that issue a lot of thought, and we have those thoughts to share with you for sure.
Okay, so is there going to be a court hearing on these pleadings after those time limits? And when do you expect those court hearings to occur?
Right. So, Mr. Chairman, Commissioner Titler, right now, there's not, but getting one sooner rather than later is sort of the next step we have to take. It took a little while to figure out who the Secretary's attorneys were for this matter, so we now know that they have some representation from the Attorney General's office on this. the and you know our what I mean without I mean so basically our position with those attorneys has been the that there is a clear controversy here. Clearly, the commission's legal position, you know, obviously wasn't unanimous, but nevertheless, the commission's legal position is consistent with the positions of most, if not all, of the other election officials involved in this transaction. And you know, at least one party we know for sure, and all of those folks evaluating the law. So so it seems to us that it's pretty self-evident that this is a real controversy that ought to get resolved. And we, I think, communicated that it's in everyone's best interest to settle that question quickly. You know, we don't, beyond having communicated that and the hope that that will get communicated to the proper folks in the client representative capacity at the secretary's office, we don't really have an answer yet.
So Tom, my question is, when do you think the court hearings will occur? And I think this is the answer you gave, right? I can't remember what my question was after your answer.
Well, the answer is yeah. So the answer is there's no date. The process we're following here is to try to get one as soon as possible. The hope is that the Secretary of State's office will recognize that it is in their interest as well as everybody else's interest to have that happen quickly and not, you know, sort of delay resolving the controversy when there's an obvious, and you know, there's obviously is one, and it's pretty simple, really, at the end of the day. So the short answer is I don't have a date. The long answer is we have a process to get a date. And as soon as we have one, we'll let you know.
Yeah, thank you, Tom. Also, you said that Secretary of State has some attorney general attorneys at their office.
Yeah.
I noticed that we have an attorney general appear at our meetings previously, right?
Yes, that's correct. Mr. Chairman, yes, that's correct.
So is there some sort of conflict if we have attorney general, attorney peer at our meetings and then they have representation from the same office in the Secretary of State's office?
Mr. Chairman, Commissioner Titla, we think we've resolved those issues by virtue of the way we resolved the relationship with the Attorney General's office. So, you know, with some exceptions, you know, Paula, could you grab Randy for me? With some exceptions, there's not going to be a likely conflict unless there is an existing matter, a historical matter, or some other issues like that. And in those situations, what we've said is, you know, we've reserved the right to object when necessary. My own view on this, and I haven't given a lot of thought, and I'm not, you know, your legal representative for this purpose, so there's nothing. But that in this matter, based on the attorneys who are representing the Secretary's office, I'm not, and given the way we have resolved our relationship with the Attorney General's office, I'm not particularly concerned about the potential conflict here based on our former relationship.
Thank you, Tom. Chairman, that concludes my questions. Thank you.
Thank you, Commissioner Titla. Any other questions in open session from members of the commission? Hearing none, are there any members of the public who wish to address this issue? If so, please make yourselves known. There's no one here in the audience, and I don't see anyone on Zoom. Okay. Hearing none, I would entertain a motion to go into executive session.
Mr. Chairman, I move to go into executive session for item number 4.
Thank you, Commissioner Werther. Is there a second?
I'll second it.
Thank you, Commissioner Payton. It's been moved and seconded that we go into executive session for this matter. I will call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump,
Aye.
Commissioner Titla.
Aye.
Chair votes aye. The vote is 5-0. We will go into executive session. Thank you.
We being served?
Yeah.
Okay, we're back in open session. At this time, do I have a motion from any members of the commission, any member of the commission?
Mr. Chairman, I'd like to move to instruct counsel, outside legal counsel, to expedite the Commission v. Fontes lawsuit consistent with other instructions given in executive session.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded that we authorize council to move ahead as enumerated by Commissioner Werther. I'll call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump,
Aye.
Commissioner Titla, Commissioner Titla, I believe you're on mute still.
Okay, hello, can you hear me?
Yes.
Yeah, I have a question on the motion made by council. She said that the motion was to expedite the litigation, I think, and then also about following instructions as made in the executive session. Is that true?
That's basically right, Commissioner Titla. I'll let Commissioner Werther restate her motion.
Yes, Mr. Chairman and Commissioner Titla, I had moved to instruct outside legal counsel to expedite the Commission v. Fontes lawsuit consistent with other instructions given in.
And
Yeah, the reason I say this, I can understand the first part about expediting, and I support that, but with regard to other instructions, I'm puzzled about that. So I know that probably we can't talk about it in this session, but I'm puzzled about other instructions.
Okay, so we're voting on the motion as Commissioner Werther stated it. Do you vote aye or nay?
I vote nay.
Chair votes aye. The motion is approved 4-1. I'm sorry. Item 5, annual budgetary calculations and 2026 spending plan. Item 5 is discussion and possible action on the annual budgetary calculations and the 2026 spending plan. Annually, we authorize a spending plan and make determinations relating to the commission's spending capacity. Tom has a brief summary of these statutory discussions, and Mike is available to discuss details of the budget plan. Tom?
So I wanted to, especially because we have new or new-ish commission members, I wanted to spend a little time just identifying what's in the memorandum you have and what's in the background material, because it's kind of an ornate process for putting this together, and basically. So basically what we're asking you to do today is we have it as one set of decisions. It really is one set of decisions, but there are two components to it. The first component is these calculations that the statute requires us to make about essentially the capacity of the fund and some worst case scenario situations and those kinds of things. It also requires us to identify a cap on certain expenditures. So you'll see in the memo that there is an administration and enforcement cap number that is at 10% of the overall spending cap, and then public education at 10%. We have some voter education funding under 16956. That is not capped, and it can't be because that includes the voter education guide and the debates, and the prices on the costs of those things are highly variable. So if you put an arbitrary cap on those, then we would have a a problem. And then candidate funding. So as we do this, the kind of most confusing thing that the commission does, in my view, is estimate the projected revenues, assuming that you're at the spending cap, that you actually get to the spending cap. That is to say, you spend to the spending cap each year. And what that tells us is based on the fund balance and the income to the fund. That tells us that if we were to spend actually spend money at the cap each year, the fund would very quickly go into the red. What that means as a practical matter is that we don't have excess funds in things. So there is the formula is sort of basically articulates a deficit, if you will, that does not exist except on paper because we don't spend at that clip, but it does dictate whether or not there are excess funds in the clean elections fund itself, and there are not. Similarly, when we do candidate funding, we do a candidate funding projection that says if basically all the candidates showed up, would we run into a shortage of dollars available for those candidates? And in which case there's some other mechanics that happen. Again, that calculation does not yield a shortfall. So really what you're doing is it's a kind of a stress test of a worst case scenario spending proposition and a sort of worst case scenario candidate. I mean, it wouldn't be worst case scenario, I guess it'd be best case scenario, but you know what I mean? But it's essentially a stress test in the statute that looks at those two things. And the formulas are because it's a stress test, the formulas aren't designed to be based on the actual spending. They're designed to look at scenarios that are set up in the statute. Then we get into the staff budget projections, right? So, and there, obviously you'll see some, especially if you're new to the commission budget, there are some numbers there that are high. That cost, things. Some of these things cost quite a bit of money, and the most expensive in a single thing that we do is the voter education guide, because it requires distribution to every household in the state with a registered voter, and it's mailed. And we nevertheless, we know from our research that is I think it's our top, right, Gina, our top most recognized asset that we do. It's the thing that people rely on. It's the thing that people when people ask me what I do for a living, I say, that guide you get, and that is our flagship product, and so that's the most expensive thing that we do. Likewise, the debates are a mandatory expenditure, and that also, in order to deliver it in a way that is effective, has some costs associated with it. Finally, the Voters' Right to Know Act asked us to look at there's a 1%? There's a 1% surcharge on fines and fees that goes to the VRCA subaccount of the Clean Elections Fund. And it asked us to look at that number and make an assessment of whether or not that we need to continue that. And for the time being, our view is we ought to, because although we have and we've not spent we've had cost-effective attorneys. Nevertheless, the amount we've taken in there is about $500,000, I think. And so, given the other, we have this entire new round of briefing. We have the additional potential other litigation that may happen next year, and then provided that litigation, is resolved favorably, we make, for example, the Prop 200 filing mechanisms, those kinds of things, which are not exactly where we would like them to be, but so those are the main things. So, typically what we've asked is that that is to essentially a motion on the entire package. I don't want to stress. I mean, I'm talking a lot, but Mike, spends months putting this all together and working with Paula and Gina and me and Avery and Alec on allocating this stuff. So I want to, if in the event that in the event you no, but I think that's important. I mean, I want to make sure that I'm not. I did think it was important to say something here, but I want to also make sure that folks that people understand that we do take a lot of time on this, and Mike puts a lot of work into making sure that this all works and we hope makes sense. So that was my kind of thought on that, Mr. Chairman. And then I think either Mike or I are available for questions if you have any.
Okay, thank you, Tom. Before we go to questions, I just want to point out a typo in the memo on the first page under public education.
Yeah.
There's a 0 left out. The public education expenditures are projected. That should be $3 million, I believe, not.
Yeah.
There's a 0 left
Oh,
out.
okay. That's correct.
Any questions or comments from members of the commission for
I had one.
staff? Commissioner Payton?
So the finished each year, and how are we with the funding for the past year?
Well, I'll take a shot at that.
Because for a while there was going down.
I think, I mean, Mike, correct me if I'm wrong, but I think we think that it's kind of stabilized. I would say about $1 million less than what it came in during pre-COVID. Is that probably right? Okay. So it's around 5 annually now. It was around 6 pre-COVID. That may change, may go down over time. I mean, it kind of depends on a lot of it's revenue from parking tickets and those kinds of things. So, post-COVID, there's a lot less traffic downtown, for example, and in Phoenix and other places. That's an impact. But it hasn't changed very much. The immediate drop was right around about 4 or 5 years ago. But that seems to be stable now.
Okay.
Any other questions or comments from members of the commission? If there's no further discussion, I would entertain a motion to approve the statutory determinations outlined in the staff memo and the 2026 spending plan.
Mr. Chairman, I move to approve the, can I see your language? The statutory determinations outlined in the director's memo and the 2026 spending plan.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you. It's been moved and seconded that we approve the statutory determinations outlined in the staff memo and the 2026 spending plan. I will call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump,
Aye.
Commissioner Titla.
Aye.
Chair votes aye. The motion is approved 5-0. Item 6, probable cause, MUR 25-01, Hector Jaramillo. Item 6 is discussion on whether probable cause exists to believe violations occurred in MUR 25-01 involving Hector Jaramillo, a 2024 participating legislative candidate. Commissioners, you have the executive director's brief. Do commissioners have any questions? Tom, is there anything you want to add?
Yeah, if I may, commissioners, so the next step in the enforcement process after reason to believe is called probable cause to believe. Under the rules, I file a brief that articulates the basis for why there's probable cause to believe. Here, in effect, the facts are unchanged from the reason to believe. And I think that although there's a evidentiary distinction there and a terminology distinction there in the sense that the probable cause process is moving closer to a finding that would ultimately result in an administrative order. That's part of that process. So, we think that the facts and law are fairly well established, that both there was late filing and that Mr. Jaramillo did not, until after we got pretty far along in the process, begin to provide information to the staff. Now, that said, one thing that I have done here specifically, sometimes we will go straight from the probable cause into the fine matter. Here, I have bifurcated those in part because I am still in communication with Mr. Jaramillo and have some confidence that we'll be able to resolve this matter. And there is a specific part of the process under the Rule 216 that talks about the formal conciliation process. So we try to conciliate ahead of time, but there's a formal opportunity there as well. So and then with respect to Mr. Jaramillo's presence, I will just tell you that I have personally understanding of his work schedule, and in this particular instance, because I have articulated to him my need to move this case along. I did not have the expectation that he would be here, nor did I, I would. So as from my vantage point, his presence here or not here for this hearing is not a negative. It is simply, this is a step that is necessary. He did communicate back to me that he did not plan to respond, but he is in communication with me, and I am. So I just would, to the extent that is a question, I would just say that although I'm not in a position to excuse an absence per se, I see nothing in the absence here that is meaningful to me in terms of his current level of responsiveness to communications from staff.
Thank you, Tom. Are there any comments or questions from members of the commission? If not, I'd entertain a motion regarding probable cause.
Mr. Chairman, I move on probable cause to believe violations of the Act and rules occurred on MUR 25-01, Hector Jaramillo, 2024 participating legislative candidate.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded that we believe cause exists to believe violations occurred in MUR 25-01 involving Hector Jaramillo. I will call the roll. Commissioner Werther.
Aye.
Commissioner Payton.
Aye.
Commissioner Crump.
Aye.
Commissioner Tidla.
Aye.
Chair votes aye. The motion is approved 5-0. Item 7, proposed 2026 meeting dates, January through July. We plan to meet next year on January 29th, February 19th, March 26th, April 23rd, May 28th, June 25th, and July 23rd. Is there a motion to approve the meeting dates?
Mr. Chair, I move to approve the proposed meeting dates for January through July 2026.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded that we approve the proposed meeting dates. I'll call the roll. Commissioner Werther.
Aye.
Commissioner Payton.
Aye.
Commissioner Crump.
Aye.
Commissioner Tidla.
Aye.
Chair votes aye. The meeting dates are approved 5-0. Item 8, public comment. This is the time for comments and suggestions from the public. Please limit your remarks to items within the commission's authority. Action taken as a result of public comment is limited by statute to directing staff to study the matter, responding to criticism, or scheduling it for further consideration. Does anyone here in person or on Zoom wish to make a comment? Hearing no one, you may also send comments to the commission at ccec@azcleanelections.gov. Item 9, adjournment. If there's no further business, I would entertain a motion to adjourn.
Mr. Chairman, I move to adjourn.
Thank you, Commissioner Werther. Is there a second?
I'll second.
Thank you, Commissioner Payton. Before I call the roll, I want to wish everyone happy holidays. And we will see you back here in January. I hope not sooner. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump,
Aye.
Commissioner Titla.
Aye.
Chair votes aye. We are adjourned.